Okay, it looks like the ticker is slowing down a little bit for people joining the presentation, so I think now is probably a good time to kick it off. Thank you to everyone who's taken the time to join us today. I'm Adrian Elmsley, and I'm the Labor and Employment Practice Group leader here for Dentons in Alberta. As you have all likely heard, earlier this month, the provincial government introduced Bill 32, Restoring Balance in Alberta's Workplaces Act 2020. This bill proposes some significant changes to Alberta's employment standards and labor relations legislation, and to some extent is designed to address some of the more problematic changes to labor and employment legislation that the NDP government introduced when they took power back many years ago in 2016, which seems like a really long time ago. The majority of changes are to the Employment Standards Code and to the Labor Relations Code. But I should just mention, we don't talk about them in any detail here. The bill also includes some minor changes, particularly with respect to some of the financial obligations of unions under other labor relations statutes, including the Police Officers Collective Bargaining Act, the Post-Secondary Learning Act, the Public Education or Education Collective Bargaining Act, and the Public Service Employee Relations Act. As of this morning, the bill is currently at second reading, but of course we do anticipate that it will be passed and come into law as scheduled. Today our presentation is going to focus on the changes to the Employment Standards Code and to the Labor Relations Code and what the practical implication of those changes will be for employers. Sarah Soberet and Christina Wendell will be discussing the Employment Standards Code changes. And Roxana Jangi and I will be discussing the changes to the Labor Relation Code for those of you who have unionized workforces or might end up with unionized workforces in the future. We've tried to plan the presentation to allow some time for questions at the end. So please feel free to type any questions you have into the chat function or the question function or the Q&A function at the bottom of your screen, and we'll try and get to some of those once the formal presentation is done. So that's it for my introduction. So I'm going to hand it over to Sarah to kick it off with the changes to the Employment Standards Code.
Thanks, Adrian. Hopefully everyone can hear me okay. My name is Sarah Soberet. I'm a third-year associate in the Denton Calgary office. And so I'll just kick us off talking about the Bill 32's proposed amendments to Alberta's Employment Standards Code. So the first proposed amendment by Bill 32 that I would like to speak to today is in regards to payments of earnings on termination. So currently in the code, when employees terminated, an employee must pay their earnings in 3, 10, 17, or 24 days, and this depends on the situation surrounding the termination. So for example, earnings need to be paid within 3 days after the last day of employment, and then it provides the requirement of written notice of termination under the code, and they work further until the end of their notice period, but within 10 days after the last day of employment, if the employer or employee is not required by the code to give notice. So the proposed amendment by Bill 32 very simply allows employers after an employee has been terminated to either pay their earnings within 10 consecutive days after the end of the pay period that the termination of employment occurred, or within 31 days after the termination occurred. So this is helpful. It allows employers to deal with all payment of earnings upon termination in the exact same way, and the employer has a bit of discretion as to when they pay the earnings, giving them a bit of additional flexibility. Next slide, please. So the next amendment to talk about is in regards to deductions from an employee's earnings. So currently, employers are generally prohibited from taking any deductions from an employee's earnings. However, the code enumerates some exceptions to this. So for example, employers can take deductions from an employee's earnings if the deduction is required by law. So for things like federal and provincial taxes, contributions to CPP, EI premiums, etc. where it's authorized by a collective agreement or authorized in writing by the employee to be deducted. The proposed amendment by Bill 32 would allow employers to, upon providing written notice to the employee, deduct overpayment of earnings paid due to payroll calculation errors, or where vacation pay has been paid in advance of an employee being entitled to it. For the payroll calculation errors, the employer has up to 6 months to rectify that, that overpayment. So this is, again, great for employers as it allows a bit of an easier recovery where payments have been mistakenly made to an employee, and you're not required to get written consent to recover those payments. You're only required to notify them in writing. Next slide, please. So the next proposed amendment is with respect to rest periods, and it's pretty much a reversion to the pre-NDP legislation. So currently under the code, where an employee works for less than 5 hours, an employer doesn't have to provide a break. But where an employee works for 5 hours or longer, the employer must provide at least 30 minutes of rest every 5 consecutive hours. The proposed amendment by Bill 32 would remove the requirement for the 30-minute rest periods after every 5 consecutive hours, and instead just requires one 30-minute rest period for a shift between 5 and 10 hours in length, and then a second 30-minute rest period where the shift exceeds 10 hours. So this is going to mean that you're not having to give your employees a break right at the 5-hour mark. You're able to schedule that in between hour 5 and hour 10, and just I'll give you a bit more flexibility when scheduling shifts and breaks and that sort of thing. Next slide, please. Thank you. So another amendment by Bill 32 is that it proposes some changes as to how certain provisions of the code would apply to parties to a collective agreement. So the proposed amendment would allow parties to a collective agreement to come to a different agreement than the requirements and minimums established by the code pertaining to things like hours of work, notice of work times, rest periods, number of days of rest required per consecutive work week, and temporary layoffs. So this is essentially going to allow for employers and unions through the collective agreement to come to a different agreement about those things. And this change may stem from the idea that the union is a sophisticated party representing the employees' interests, and so the certain provisions of the code pertaining to those certain requirements and minimums don't necessarily need to apply. But in any event, it allows for some flexibility where parties are subject to a collective agreement. The next amendment that we're going to speak to is in regards to averaging arrangements. So I don't know, this is one of the exciting changes to the code with respect to averaging agreements. I guess it depends who you talk to about it. But under the current code, averaging agreements allow employers to schedule an employee or group of employees to work longer hours per day at the employee's regular wage rate. The employer can average up to 12 weeks for an employee's hours of work over a period to determine overtime pay or time off with pay. However, entering into such an agreement under the current code requires employee agreement, and you're limited in your averaging agreement to a term of 2 years. So the proposed amendments under Bill 32 would do away with what we are now currently calling averaging agreements and introduces us to averaging arrangements. An employee agreement is not required for averaging arrangements. However, an employee must give 2 weeks notice to start or to change an hours of work averaging arrangement. Further, employers can average employees' hours in such an arrangement in order to determine overtime pay or time off with pay over a period of up to 52 weeks. So that's a pretty substantial period of time from the current code. In addition, arrangements are no longer limited to a maximum 2-year period and can continue on indefinitely. Finally, Bill 32 proposes to introduce a 6-month right of complaint by an employee for an employer's non-compliance with an averaging arrangement. So if an employee notices the employer is not compliant with the terms of the averaging arrangement, they can make a complaint to employment standards for up to 6 months from the point of non-compliance, and the ESC will investigate and take any further steps required. So these changes for the averaging arrangements have some great implications for employers, add some flexibility back into this concept for sure, and actually kind of reverts us closer to what the similar concept of compressed work weeks in the legislation pre-NDP. Next slide, please. Okay, so finally, I'm going to talk about just the transitional provisions in relation to the existing averaging agreements that may exist. So Bill 32 provides the transitional provisions for existing averaging agreements that are in effect when the changes will come in up for Bill 32 come into effect. Averaging agreements will remain valid until the earliest of the following, where not part of a collective agreement. So the day the averaging agreement terminates, so for example, in the code, there's a maximum of currently in the code, there's a maximum of a 2-year term. So at the end of the 2-year term, it could terminate by a party to the averaging agreement by giving 30 days notice. If there was a group of employees that had agreed to the averaging agreement, you'll just need majority consent for termination to be able to proceed with terminating the averaging agreement, and then where it's canceled by the director. It's not up on the slides, but where part of a collective agreement, the averaging agreement can be terminated the day a subsequent collective agreement is entered into by a party giving agreement and 30 days notice in accordance with the collective agreement or by the director. So I'll now pass the mic over to Christina to continue the proposed amendments to the Employment Standards Code. Thanks.
Thanks, Sarah. So I'm going to finish up the talking about the rest of the changes to the Employment Standards Code. The first one on the next slide there, perfect, is with respect to the average daily wage. And that becomes relevant when calculating holiday pay, the general holiday pay. So currently under the code, the average daily wage is 5% of an employee's wages, vacation pay, and general holiday pay that was earned in the 4 weeks immediately before the general holiday. So while it doesn't include overtime pay, it does include both vacation and holiday pay in those 4 weeks. So what is being proposed with the changes is to change how the average daily wage is calculated, really to give employers some more flexibility and enable them to determine the most favorable calculation for them. So the proposed change is to calculate it by averaging the employee's total wages, so wages only, no longer will it include the vacation pay or general holiday pay in that time period, in one of the following 2 periods, which is chosen by the employer. So either the 4-week period immediately preceding the general holiday or the 4-week period ending on the last day of the pay period that immediately precedes the general holiday. So that gives the employers the flexibility to decide how they want to calculate it. The next one. So the next change is with respect to vacation entitlement during the job protected leaves. Currently the code is silent on this, so this is meant to provide some clarification, and I think it really just clarifies what I think most employers are doing, but it provides that where an employee is on a job protected leave under the code, the period of time that they're on that leave is to be included when calculating the employee's years of employment for the purposes of determining the vacation entitlement. So under the code, for example, from 4 consecutive years to 5 consecutive years, the vacation entitlement goes up from 2 weeks to 3 weeks. So if you had an employee who was on, say they've been working for 4 years and then they are on a 1-year leave, that 1-year leave would be counted for putting them up to the 3-week entitlement for vacation time. Vacation pay wouldn't be impacted because it's dependent on the wages, which as their job protected, but unpaid leaves, the employee wouldn't be earning any vacation pay during that period. So the next change is with respect to temporary layoffs, and there's a few changes on this front. The first is with respect to the notice that's required. So currently under the code, unless there's a collective agreement that provides otherwise, employers have to give employees advance notice that they're being placed on a temporary layoff. And that depends based on their years of service. So for employees with less than 2 years of service, they're entitled to at least 1 week's notice. For employees with 2 years or more of service, they're entitled to at least 2 weeks notice. There is a third provision where there's unforeseeable circumstances that prevent the employer from providing that notice. The requirement then is for the employer to give as much notice as is practicable in the circumstances. And from the work we've done over the past few months, certainly a lot of employers were relying on that last provision to provide less than the 1 or 2 weeks notice otherwise required. So the proposed amendment simply does away with the notice requirements altogether, so there won't be the requirement to give advance notice of a layoff under the proposed changes. The next change is with respect to the length of the layoff. So currently under the code, employees who are laid off for a period exceeding 60 days within a 120-day period are deemed to be terminated. There are a number of exceptions that allow that period to be extended by agreement. One of the more common ones, and again, one that has been used a lot in the last few months, COVID related, is where the employer continues the employee's benefits. So if the parties agree to an extension, that 60-day period can be extended. What's being proposed is to extend the 60 days to 90 days. So employees who are laid off for a period exceeding 90 days, still within that 120-day period, will be deemed to be terminated. And it maintains the same exception, so that period can be extended by agreement as well. The next proposed change for layoffs still, on the next slide, is with respect to termination pay. And this, I think, has just been introduced to provide some clarity. It's not something that was contained in that is contained in the current code. But the proposed amendment will clarify that where an employee who's laid off is deemed to be terminated, so when they run over the currently 60, or I guess it'll be 90 days out of the 120, then the termination pay that is payable is what's in accordance with section 57.1 of the code. And that's the section that says that termination pay on a without cause termination is equal to the wages the employee would have earned if they'd worked regular hours for that applicable termination notice period. So that's just meant to provide some clarity to employers on that front. The next slide is just with respect to the COVID-19 changes. So currently the code contains the provision that was introduced more recently to deal with the COVID-19 impacts, which provides that the layoff period, if it's for reasons related to COVID-19, the layoff period can be up to 180 consecutive days. So under the proposed amendment, that extended period will be maintained. So not a change there, but I just wanted to clarify that was being maintained with the current changes, so there's no confusion with the 90-day period. So on the next slide, I just want to briefly go through some of the proposed changes to the variances and exemptions. There's two different ways to get variances and exemptions. So the first one I'm going to talk about is with respect to requests of the director. So where it's a director giving a variance or an exemption, there's only certain provisions that are set out in the regulation that can be varied or exemptions granted. The current code provides that employers can apply to the director. It specifically states that employer associations or a group of employers cannot apply. The director has to be satisfied that certain criteria under the regulations are met. And then there's certain notification requirements as well for the employees. So they have to be notified of the variance or exemption, as well as of any amendment or revocation. By receiving a copy personally, the employer also has to post a copy in the workplace and online. and in any other manner that will inform the employees. Just for your reference, the provisions that can be varied or exempt is the 3-hour minimum pay, extending days or extending hours of work, or extending the averaging period under the current averaging agreements. So what's being proposed for the change will specifically allow employer associations or group of employers to apply to the director for the variance or exemption. And that's in addition to employers. It will repeal the requirement that the director has to be satisfied that those certain criteria under the regs is met. And the employer is only required to provide a copy of the variance or exemption or amendment or revocation to each employee to who it applies. So it simplifies the notice provisions. I should note that while this is the current code, there was one of the COVID orders that did provide that any applications after March 17th could be done by an employer association or a group of employers. Those are with respect to some certain provisions. So the notice requirements for work times, hours of work confined, break times, days of work and rest. And it follows a slightly different process than the existing process. So there were some provisions that were put in place for the COVID implications. So the next slide. So there's also variances or exemptions that can be obtained from the minister. And the minister can grant those with respect to any of the minimum standards. Currently, the code states that the minister can order it on application by an employer association or a group of employers. So it's not something that an employer can apply for. Again, there was one of the COVID orders that provides that after March 17th, employers can apply. So that's on a temporary basis. The code also provides currently that the order is for a maximum of 2 years and cannot be renewed. There's some additional stated criteria in the regulations that the minister has to consider. Although that provision has also currently been waived by the temporary order after March 17th. The proposed changes are to allow that those applications can be made by any of those groups. So employers, group of employers, or an employer association. They will also be getting rid of the time limit for the order and the prohibition on renewals. And currently those variances or exemptions are posted online, and it doesn't seem like that will change. So the next slide is with respect to limitation periods on complaints. And Sarah mentioned this one. These just relate to the limitation periods, the 6-month period for making a complaint where the employees are subject to the averaging arrangement. So it just clarifies the limitation there, and also clarifies that the period that the order will apply for will date back to the end of the averaging arrangement as well. So the next one I want to talk about is the changes to the group terminations. A few changes there. The first is with respect to the amount of notice required. And again, this is another one of those pieces that came up a fair bit with the COVID related issues. So currently the code is states that where an employer intends to terminate 50 or more employees at a single location within a 4-week period, the employer is required to give written notice to the minister on a rising scale of 8 to 16 weeks, depending on the number of employees who are terminated. So that has also been changed by one of the temporary orders. So any group terminations that fall within that section after March 17th, the requirement is just to give notice to the minister as soon as possible. What's being proposed for the more permanent change is intended to simplify that and go back to more of how it was before. So where the employer intends to terminate the employment of 50 or more employees at a single location within a 4-week period, it's simply a 4-week notice period that's required to the minister. It also is proposing to add kind of an exception where if the employer is unable to give 4 weeks notice, it must give notice as soon as is reasonable and practicable in the circumstances. So on the next slide, just some more specifics on what is required for notice. So currently, as the code is stated, the notice has to include the number of employees, the effective termination dates, and any other information required by the regulations, which currently there is none. It also provides that notice has to be given to the bargaining agent, or where there is no bargaining agent, to the affected employees. Again, that last notice requirement is something that has been waived by the COVID order for any group terminations after March 17th. What's being proposed with the amendments is that the notice must include the number of employees and the effective dates. That's maintained, but it dispenses with the requirement to give notice to the bargaining agent or employees, so in line with what the current order is requiring. So on the last slide there, just the coming into force. Most of the proposed changes to the Employment Standards Code that we've talked about will come into force on November 1st of 2020. A number of them, such as the proposed changes to the temporary layoff provisions, variances and exemptions, and group terminations are set to come into effect on August 15th of 2020. So just around the corner. And with that, I will turn it over to Roxana Janyi to talk about the changes to the Labor Relations Code.
Thank you, Christina. Good morning, everybody, or I should say good afternoon now. I'm a senior associate at Denton's in the Employment and Labor Group. As Christina mentioned, in the next portion of the presentation, I will be along with Adrian Ainsley will be discussing the amendments under Bill 32 in relation to the Alberta Labor Relations Code. And this will be, again, relevant to all those employers dealing with a unionized environment, or potentially maybe of interest to those that may become subject to a unionized environment as well. So to jump right in, one of the amendments that is proposed under the new bill will be to expand the powers and the jurisdictions of the Labor Relations Board. Now, these amendments are primarily being implemented to enable the Labor Relations Board to serve employers, unions, and employees more efficiently by reducing unnecessary hearings and also potentially addressing some of the backlogs and the wait times currently associated with processing matters. So to achieve this objective, what Bill 32 proposes to do is to expand the board's powers to summarily dismiss certain types of applications. Currently, specifically under the current legislation, the board has the ability to dismiss certain types of applications summarily, where the board is of the opinion that the matter may be vexatious, trivial, or frivolous. Now, these types of cases have also been expanded now to include situations where matters that are applications and matters where the board may be of the view are being brought with improper motive, or where a matter is an abusive process. So these could potentially be situations such as where a union or potentially even an employer brings an application as part of a fishing expeditions. But it'll be interesting to see potentially how these areas, how this section gets interpreted in the future. Further, the proposed bill also expands the types of cases where the board chair or the vice chair can hear matters alone. Currently under the Labor Relations Code, the chair and the vice chair can hear certain issues. These will now also be expanded to include judicial review applications of arbitrators' decisions, which generally previously were being heard by a panel, which consisted of a chair, vice chair, or the vice chair, and two members of the board. Further, the new bill will also allow the chair or the vice chair to hear matters where the chair is of the opinion that it is necessary due to an emergency. Currently, the bill provides no guidance on what could constitute an emergency. So again, this is one of those items where we'll kind of have to wait and see how the section of the bill potentially unravels when implemented. Now, moving on to the next slide. The new bill will also make amendments to sections dealing with remedial certification. So for those of you who may not be familiar with this concept, generally speaking, the remedial certification provisions generally allow a board to certify a union as a remedy when an employer is found to have committed an unfair labor practice or a prohibited practice under the Labor Relations Code. So under the current code, the board does have the authority to direct a certification, so to certify a union with or without a representation vote, where the board is satisfied that an employer committed an unfair labor practice, or I should say a prohibited practice under the code, such as potentially interfering with an organizing drive. Bill 32 proposes to limit the Labor Relations Board's power to certify or to also refuse to certify a union as a bargaining agent for a unit of employees. Specifically under the proposed changes, the board will only be able to direct a certification where a prohibited practice results in a representation vote that does not reflect the true wishes of employees in a bargaining unit, and where there's no other remedy that could sufficiently counteract the effects of the prohibited practice. So these two conditions will need to be met before a remedial certification may be granted. The new amendments under the bill also allow the board to order another representation vote to be conducted, and to also do anything to ensure that the second representation vote reflect the true wishes of the employees in a bargaining unit if it is determined that, again, there has been a prohibited practice in place. So those are two new, I'd say, modifications to the remedial certification sections underneath the code that will are proposed under the new bill. Moving on to the next slide. There are new provisions that will be also introduced under Bill 32 relating to financial disclosure and union dues, which has caused a little bit of controversy, I would say. Under the proposed changes, unions will now have a legal obligation to provide financial statements to their members as soon as possible after the end of their fiscal year end. And this will be at no cost. Now, the financial statements must contain information in sufficient detail to accurately disclose the financial condition and the operation of the trade union in the preceding year, and any other information that may be prescribed under the regulations. The amendments will also allow for union members to file complaints to the board where the union fails to meet this obligation with regards to financial statements, or where the union fails to provide financial information in the form prescribed by the code as well as the regulations. Where a complaint is filed, there'll also be provisions that allow the board to order the union to provide financial statements, or also provide statements that meet legislative requirements, or potentially in another prescribed form as the board considers appropriate. Further, there have been changes in relation to reporting requirements for union dues. Specifically, the proposed changes also introduce provisions that will require unions to provide their members with a breakdown of how their union dues, initiation, or assessment fees are spent. So under the proposed amendments, unions will need to disclose the amount or the percentage of the union dues, again, assessment fees or initiation fees, that are allocated towards general social causes or issues, charities or government organizations, political campaigns, as well as core union activities, which would include activities related to collective bargaining and representation of a member. Additionally, employees will, under the provisions of the bill, will also have the option of opting in to pay only the union dues that are related to non-core union activities. So what that means is a member of a union will have the ability to say, I only want to pay the portion that goes towards representing me in labor relations matters, whether that's collective bargaining and so forth. They'll have the ability to opt out of paying the portions that may be allocated to political campaigns, social causes, charities, and so forth as well. So that will be an election that the employees will have, the bargaining unit members will have the ability to elect as well under the suggested provisions. There are also provisions in the code that will be introduced that prohibit the employers and unions obviously from influencing an employee's ability to elect and opt in to the election of with respect to their union dues as well. So now these provisions are quite a shift from the current state of affairs. Currently, unions have no obligation to report to their members regarding their financial position or to provide a breakdown of how union dues are spent. Further, under the current Labor Relations Code, it's mandatory for all union members to remit full dues to their unions regardless of where the dues are spent. The primary idea behind these provisions is to increase transparency in the workplace by requiring unions to provide members with financial statements so employees know how their dues are spent. So moving on to the next change. The next change deals with certifications and revocation applications and procedures. Specifically, Bill 32 will make changes to the procedure for certification and revocation applications. Under the current legislation, the board must fully, I should say, determine these applications no later than 20 to 25 days after the application's filed, with limited power of the chair to extend these timelines. It has been found that these timelines and restrictions have been, on a practical level, arbitrary, inflexible, and not insufficient in terms of being able to properly address issues that may come up in these types of applications. So under the new provisions proposed under the Bill 32, these time limits will be expanded and the board will be required to complete its inquiries and considerations as soon as possible, but no later than 6 months after the application is filed. Moving on to the next slide. Another change that will be happening is early renewal of collective agreements. So since 2009, there was a board decision that significantly restricted the ability of parties to a collective agreement to enter into early renewals of a collective agreement. The proposed legislation would reinstate the ability to renew collective agreements early. This will allow for greater flexibility to ensure that a collective agreements are consistently serving their purposes. Early renewals of collective agreements would be only permitted under certain situations or where certain conditions are met under the proposed changes, which would include the employees that are subject to the collective agreement must be informed by their union that no applications for certifications or revocations will be permitted if the employees vote to enter into the new agreement. And also employees must then also vote to enter into a new agreement early. So these changes will again sorry, I hope you guys can hear me. Okay, sorry, I'm not too, oh, sorry. So these changes will allow employers to be more competitive by allowing new collective agreements to be negotiated with their unions and then ratified by employees outside of the open period. So this brings me to the end of my presentation. I'll pass it along to Adrian Emsley to provide an overview of the remaining amendments to the code.
Thanks, Roxana. Some interesting changes there, some of which I think are a long time coming. I'm sort of moving on with some more of the changes to the Labor Relations Code. And the first one I want to talk about is the changes that they have finally made to the issues of picketing and secondary picketing in the event of a strike. And one of the biggest problems we've seen in Alberta and across Canada in practice is a practice whereby when a union establishes a picket line, what they've tended to do is, and what they've been allowed to do, is to obstruct entrances and exits of struck employers under the guise of free communication, even though there's normally no attempt to communicate. What essentially the picket lines do is they stop the vehicles from crossing the picket line for a certain period of time, which they say is for the purposes of communicating, even though they don't attempt to communicate. And what happens is you get a cumulative effect of all of these delays, resulting in a very long delay for people who want to cross the picket line to be able to cross the picket line. For example, last year, we were involved in obtaining an injunction during the CN strike, where the picket line established there was stopping vehicles leaving the intermodal facility for 5 to 10 minutes on their way out. And what happened was that within half a day of the union doing this, there was a 4.5-hour delay for vehicles trying to leave the property, which obviously causes all sorts of safety issues and a lot of problems. So what Bill 32 does is it changes that practice now, where the boards were generally open to allowing unions to, or picket lines to delay vehicles from going in and out or crossing the picket line. And so what the, under the old code, there was no specific restriction. It was up to the board's discretion, and the board would typically allow this kind of activity. Under the proposed amendments, a pretty significant change has been made. Under the new legislation, obstructing or impeding a person who wishes to cross a picket line from crossing the picket line is now prohibited as a wrongful act. So specifically, unions can't do that, whether they call it communication or not. They're not allowed to block people from entering or exiting a property. Next slide. The next change to picketing deals with the issue of secondary picketing. And secondary picketing doesn't come up that often, but it's basically a practice where the union sets up a picket line at the location of a company that is not directly involved in the labor dispute, but it's usually another employer that's assisting the struck employer from carrying on business. And currently the code identifies the 3 typical categories that qualify as locations where secondary picketing will be allowed. And as you can see on the slide, typically the code automatically permits secondary picketing at a premises where the work that is normally done by striking or locked out employees is done during a strike or lockout. So if they move their production facilities to a different location and have non-union workers performing that work, then that would be considered a secondary location. A place where the employer uses to further lockout or resist a strike. So again, anywhere where, for example, if there were deliveries that are supposed to be going to a struck area, they may deliver those items to a different warehouse. That warehouse could be picketed. And then also a premises where a third party is assisting the employer in furthering a lockout or resisting a strike by performing services for the employer that it does not normally provide. So again, kind of contracting out some of that work that the struck or that the employees that are on strike would normally be performing. Now, under the current legislation, the way it works is that the union sets up the secondary picket line, and if it's not a proper secondary picket line, it's up to the person who is getting picketed to go to the board and get the picket line removed. And as you can imagine, that requires a certain amount of time, and during that interim period, the picket line remains at that premises whether or not they've actually end up having the right to do that. So what the proposed amendments do is they change the order of operations. So basically it recognizes that until the board has decided that you are a secondary location and that you can be picketed, the union is not allowed to picket at that location. So the way it accomplishes this is it requires the union to go to the board and make an application to the board and to obtain an order from the board allowing them to picket those secondary sites. So essentially it preempts some of the harm that can arise out of sort of automatically picking someone that you think is a secondary target when they aren't properly a secondary target. Next slide. The next change deals with the measures that the board can take in reaction to an illegal strike. And In the past few years, there have been some issues with illegal strikes in Alberta. I think the most prominent one was probably the illegal strike or the wildcat strike that happened in and around the new remand center in Edmonton. And I think this is probably a little bit of a reaction to this, to give the board some more efficient tools to deal with illegal strikes. So what it does, what this section does, or this amendment does, is it expands the board's power to suspend the deduction and remittance of union dues for up to 6 months in the event of an illegal strike. So basically it creates the potential for a fairly significant financial penalty for any union that engages in an illegal strike. And it also has the flip side where an employer who conducts an illegal lockout, which I've got to say is pretty rare, but it's possible. If the employer is acting improperly and illegally locks out their employees, the flip side of the power is that the board can actually order that employer to pay the union dues and fees for up to a 6-month period of time as well. So it cuts both ways, and it gives the board just a little bit of power to bring a little bit of financial pain on any person that wants to engage in illegal strike activity. So again, that's a bit of a bolstering of the board's power, and I think it's going to be effective and helpful. Next slide. The next one deals with first contract arbitration. And first contract arbitration is something that was introduced by the NDP here in Alberta during the last round of amendments that they undertook. It's something that has existed in other jurisdictions. It just didn't exist in Alberta before. And what it allows it allowed essentially unions, although it's open to both sides, is it allowed the board, if new parties to a collective bargaining arrangement, so a newly certified employer, typically what happens is, or what does happen is, they're required to negotiate a collective agreement with the union. And because these relationships are new, sometimes there's a lot of battling going on as to what that agreement's going to look like. And the employer may dig its heels in and say, I really need to set the terms of this agreement, and I'm going to bargain this very hard. What the changes that the NDP brought in was they allowed the union to go to the board and basically have the board order that an arbitrator determine the terms of the first collective agreement. So essentially it takes the bargaining power away from the employer and puts it in the hands of a third-party arbitrator. And the threshold under the current legislation is rather low. All the board has to do is be satisfied that arbitration is otherwise appropriate. So it's a fairly low bar to get over, and it's something that I think was fairly upsetting to employers. With the idea that a third party would be able to set the terms of their collective agreement. And so what you see with the new amendments is that they haven't removed first contract arbitration. There's still a possibility that that can happen, but the amendments have sort of significantly reduced the scope of power to order that. So the board may still order a first contract arbitration, but there are certain requirements that have to be met. Specifically, the board has to be satisfied first that arbitration is necessary. Second, that the employer or trade union has failed to comply with the act. So as an example, they may have refused to meet to collectively bargain, or committed some form of unfair labor practice while trying to bargain. So in other words, there has to be a violation of the code. It can't just be regular bargaining that's going on, or hard bargaining. And the other requirement is that no other remedy or remedies would be sufficient to counteract the effects of the failure to comply with the act. So basically, this still leaves it up to the parties to bargain a collective agreement so long as they're playing by the rules. And so long as they're playing by the rules, the board no longer has the power to order first contract arbitration. What you basically need now, and I think it's a more appropriate approach, is to say, we're only going to order first contract arbitration if we think someone's not playing fair. And I think that's probably an appropriate compromise in the circumstances, and it's certainly a change to what we have now. Next slide. This is a kind of a quirky change, and it deals with the powers of arbitrators. And one of the more problematic amendments that the NDP sort of snuck into the Labor Relations Code when they made the sort of significant revisions to the code a few years ago, was that they allowed arbitrators to extend the time for taking any step in a grievance process or arbitration procedure set out in a collective agreement. So essentially what you would have is you would have a collective agreement that would have time limits in it. For example, if a grievance was going to be filed, it had to be filed within 30 days of the grievance happening. And this allowed parties to sort of have some certainty as to whether an issue is dead or not. And what this amendment did was it allowed arbitrators hearing those sorts of claims to basically arbitrarily extend those deadlines if they thought it was something that should happen. And this was obviously quite frustrating for, I think, primarily employers, because they'd actually bargained these timelines into their collective agreement, and those timelines were there to give the parties some certainty. And so one of the amendments that's coming through Bill 32 is that the code will be amended to eliminate that power. So the arbitrators will no longer have the power to extend time limits, mandatory time limits that are set out in the collective agreement. So they'll actually have to, as they're supposed to, follow the collective agreement. So I think that's a very positive change, and one that I think was really necessary. Next slide. The next slide is a little bit more technical. It deals with sort of the board's power to review arbitration awards. It simplifies what the board will look at and how they'll approach these sorts of reviews. And the other significant change is it empowers the board to award any costs it deems appropriate in response to an application to review or question a decision. So they've got the power to order costs. And again, I think this is a reflection when this was first brought in again by the NDP, where they moved the review of arbitrations away from the courts and to the board. It took away the power of parties that were subject to a review from being able to request costs. So that has been reintroduced. Next slide. This one I like to call the reverse onus rule. Under the, again, another change that the NDP put in when they revised the code was, and the way the current code reads is it places a reverse onus, in layman's term, a presumption of guilt on employers accused of certain prohibited practices, primarily discrimination based on union involvement or activity. So essentially, if an employer is accused of conducting a prohibited practice or discriminating against someone for union activity, it's up to the employer to prove that they didn't do it, rather than to have the union prove that the employer did do it. The proposed amendment changes that rule, and it restricts the reverse onus or the presumption of guilt to only cases involving prohibited practices that involve the discharge or discipline of an employee due to union involvement or activity. So it certainly narrows the scope. Before it was, if an employee said, I didn't like the shift that I was put on, and I think it was because I was a union member, there would be a reverse onus on the employer to try and justify that shift change. That has changed now, so it's only in cases where the employee has been discharged or disciplined. The next slide. The next slide is really primarily for unions, and it deals with duty of fair representation complaints where a union member might complain that the union has not done a proper job in defending them or defending their interests. And it allows the boards to summarily dismiss a duty of fair representation application where the complainant has refused to accept a settlement that is fair and reasonable. And again, most of us don't see this unless you actually act for unions, but duty of fair representation complaints take up a lot of the board's time, and there are a lot of those kinds of complaints. So it's a good step to be able to get rid of more of those complaints on this basis. Next slide. And then the last one I'm just going to touch on because it's a very specialized area, but the amendments are making quite a few significant changes to labor relations in the construction industry. And we've just sort of highlighted a few of them here. First, it allows non-registration trade unions to organize all employee bargaining units in construction and maintenance industries. That wasn't allowed before, so that's going to be a significant change for the CLACs of the world and those sorts of things. It allows the building trades of Alberta the ability to negotiate project agreements on a multi-trade basis outside of construction registration agreements. So again, it's pretty technical, but it allows a lot more flexibility for the kinds of terms that are going to be used for major project agreements. The next change is it permits existing collective agreements to remain in force after a successful union raid. Again, pretty technical, but an important change. And then it also makes changes to major project agreement approval process and the rules. So where you have a large project where you don't want labor disruption, and you have you create almost a bubble where collective agreements have different rules. It's made that a little bit more user-friendly, and it's expanded the scope of when they can apply and how easy they are to get. They used to be very difficult to get. Now I think the idea is for them to be a lot easier. And so next slide. That concludes the formal part of our presentation. I note it's 12:58, but I also don't think there are a ton of questions here. If you have any, feel free to type them in. If we don't get to them this afternoon, we'll try and follow up with anyone that leaves a question that needs to be answered. Just looking at what we have here, there's one question there about a union environment that has a daily wage for calculating stat pay. I think, Sarah, this falls into one of the things you were talking about, collective agreements. Can you, if you can see that question, can you answer that?
So I don't know that it talks about the bill will change for calculating the stat pay under the ESA. It's going to allow parties to a collective agreement to come to different terms as it relates to hours of work and that kind of thing. But Claudia, we can follow up with you later.
Okay.
Maybe I can pipe in here too, because I talked about the average daily wage change. I don't recall seeing anything in the transitionary provisions that specifically dealt with that. My thinking is if an employer's been following a certain process and paying in a certain way under the collective agreement, I don't know that they'll unilaterally be able to revert to a lower or less beneficial one. So that my guess would be that would be something that have to be worked through with the union.
Yeah, that would be my inclination too. I think they would have to bargain that at the next round.
Yeah.
Okay.
I see there was the one piece on that temporary layoff, and that was just the clarity that I added in. So if it's a COVID related layoff, that is the 180 days, but otherwise it's up to 90, or the proposed change is up to 90. So I did think that was a bit confusing. So just wanted to clarify that.
Yeah, and I think it has been a little confusing because I know I've had a couple of clients call me and say they've been to the Government of Alberta website, and it still talks about the 60 out of 120 days, and it doesn't reflect the COVID changes of the 180 consecutive days for COVID related layoffs. So I think there is a bit of confusion about how long they last these days. All right, well, that's pretty efficient. We're at the end of the time and we don't have any more questions left. So again, thank you very much to everybody who attended. You'll receive an email. This presentation is going to be posted online, and I believe you'll also receive a link to watch this again if you want to, or to get a copy of the slide deck that we used. So again, thanks everybody for coming, and thanks to all the presenters for providing us with the insight, and we'll see you all again in our next presentation, which will come either early in the fall. We have some scheduled on a national basis, and if anything unusual comes up before then, keep your eyes peeled and we'll let you know if there's another presentation coming. Thanks everybody.